Hi, everyone. I'm immigration attorney John Khosravi. Thank you for coming in for episode 212. Sorry, I've been out for a little bit. September was a little bit of a chaotic month, just a lot of work in the magazine and all that. But definitely check out the magazine. New issue did come out. I haven't even been plugging it that much, but you're going to be hearing more about it. The third issue of the Immigration Lawyers Toolbox magazine, special edition on O1A visas. It's the content in there is tremendous, and I really want to thank all the colleagues who helped. And we're going to be talking with everybody in the coming months about it, interviewing them about their articles, about their work. I do want to thank all the sponsors, in particular DocuWise, who sponsors the podcast and the magazine. DocuWise being a good all-in-one service for case management, forms, USCIS, updates really quickly, just an all-around good service. And they give you additional 10% off their annual plan if you use our subscription code. Go to DocuWise.com/immigration-lawyers-podcast and use the code Immigration Lawyers Podcast. And if I'm saying it wrong, the website URL or anything, you can email them and they'll fix it for you. Kevin Gregg, our guest today, who's on our regular, also sponsored by them, and so it's a double for DocuWise. They got two podcasters that enjoy their product. Now, I also want to mention Visa Franchise, another one of our sponsors for the magazine, which is a really cool project. I did an interview with them. We're publishing soon about what the product is at visafranchise.com. But essentially, they help foreign nationals be able to better understand their investment that they're going to get into if they're going to do an E2 visa in particular. They do some E5 stuff, really E2. So it's really neat to help your clients figure out with some proper judgment of what's going on with the business plan. Definitely listen to the service provider episode that is coming up and listen to it. I think you're going to get a lot out of it. They have a website you can even go to, visafranchise.com. And then log in and check out the plans they have. Hundreds of franchises they've analyzed and stuff. So it's a real cool thing, and I'm going to be doing a lot of work with them. Catch their article in the Toolbox magazine that talks about their service to get a better idea of what's going on. And one other thing, if you're interested in a marriage green card course, a lot of our listeners are people starting to switch and come to immigration law, let me know. Email me at info@immigrationlawyerstoolbox.com. I'm going to be doing a fiance visa course by popular demand. So if you're interested in learning about the fiance visa, what goes on there, we're going to create a live show, live program for subscribers as people get into it, and then have recordings that people can watch after the fact as well. Just email me, let me know you want to join a live course, and we'll talk about all the other stuff that you want to ask about the program. But with that, let's get it on. So let's bring in Kevin. Kevin, welcome back from across the world, from the other hemisphere, southern hemisphere. Welcome.
Let's get it on, indeed.
So, Kevin, did we miss any podcasts? I think you just came back right in time, or I may have lost track of time, but did we miss anything? Or
we missed August. We didn't do August. I could have done August geographically, but I just could not do it.
Take a break. It's no problem. We'll do 11 a month instead of 12. Well, welcome. You're on your honeymoon. Went to South Africa. Saw South Africa for the beauty that it is. So thank you for coming back and share with us a little bit of your insight from being in a place most of us are never going to go to, probably.
That was awesome, and I highly recommend if anyone's interested, if anyone's got it on their bucket list. And COVID is terrible. COVID has ruined so many things, and COVID made it quite dangerous, expensive to get a rapid test to get on the flight, and I would have been stuck in South Africa for 10 days if we had failed our COVID test in South Africa. But once you're there, it's pretty wonderful because we had a lot of safaris to ourselves. A lot of went to the Cape of Good Hope, had the whole place essentially to ourselves. There were nights where we were staying in hotels in their wine country, had the whole hotel to ourselves, which actually I don't like. That's a bit creepy, but it's a beautiful country, and the safaris are everything they're cracked up to be. So it was great, and thank you for the congratulations.
Wonderful.
And getting married was great too.
that definitely. We have a question from Facebook user on our page. Any giraffes? Question mark.
So many giraffes and elephants that it becomes like almost like, oh, just another giraffe, just another elephant. Oh, wow. Like no big deal. When we got to the lodge and waiting for our safari, the lodge itself is in the middle of the bush and it's on a river. And right when we sat down for like a lunch, a whole herd of giraffes started walking down to the water on the other side. It's like that opening scene in Jurassic Park with the brontosauruses, where, they realize they're surrounded by brontosaurus. So, it's a cool thing. Very lucky, very fortunate.
Well, while you were there, I went with my family to the zoo in Santa Barbara. We fed some giraffes there, and we saw them in captivity. That was fun. Did you
Yeah.
get to feed them and stuff, or how close could you get it with the interaction with them?
You can get really close, but you know you're not supposed to touch them or mess with them because you are in their territory, and
That's true.
you're not. Saw hippos, lions, lots of rhinos, lots of different stuff. The wild dogs, hyenas, just you name it.
Oh, that was kind of scary. Hippos are like one of those dangerous animals. More human dies for hippos than lions or something like that.
Yeah, no, but no, it was very cool. It was awesome, and even the minor things, even seeing a gecko at night, for example, or an elephant that's kind of getting aggressive. It's just like you realize you're right there.
Yeah.
It's Saw a leopard with a kill in its tree. That was pretty gross. It looked a little too much like a human, even though I know it was
Yeah.
an antelope.
Well, it's good to see reality. It kind of it gives you perspective because we're in cities and everything's machines and computers. That just how we're talking is so detached from our real nature, where we came from. So it's a good thing to see that.
That's right.
Um, Talking about detached and inhumane kind of stuff. What's going on in federal court right now? What's been happening?
I can't. I cannot ascribe to that intro. That's just. I mean, look, the DC Circuit just stayed the district court's injunction on Title 42. That is not my subject area, but I know the issue and the fact that the Biden administration continues to follow the Trump administration's really unique use of Title 42 to
Yeah,
prevent asylum seekers from getting any hearings just turned around in the United States. I don't see what the justification really is there, especially when there was an injunction. The Biden administration did not have to appeal it to the DC Circuit.
yeah.
So that seems a bit inhumane to me. But not my subject area. We'll see what happens long term. But
It just goes to show that there's a bipartisan sentiment against immigration, even with Biden coming. I mean, it's not bad as Trump, but in the internal workings of DC, it's rare that people are really, really pro-immigration in a certain way. I'm surprised Reagan got the amnesty done. A lot of times it comes from the unexpected. Like Nixon pulled out of Vietnam. It's always like it looked like he was going to double down. He ended up pulling out. Reagan, you wouldn't assume had done amnesty. What you think is going to happen 8 years of Obama, even with what you mentioned frequently, it would happen with the Congress. There's ways of pushing stuff through and putting political capital against it. But another side, I'm not even sure if I don't want to go into this. Sorry, I'm opening a topic I don't want to go to, but comprehensive immigration reform. I'm sure there's going to be all these loopholes and things that got you things that are in there that I'm kind of like the devil you know is better than the devil you don't know. It's probably better to just keep things as they are, but it's not the best too.
Ira is a pretty rough devil. I sympathize. I sympathize a bit with the Biden administration on it because immigration has become such a political football, and if you've got thousands of asylum seekers flooding the border, even though that's allowed under international law, it's going to completely be used as a hammer over you
Yeah,
during the midterms. That's why, and I'm not just saying it because he's my boss, but like I contribute to Immigrants List, which Ira Kurzban is one of the founders on the board, and they're the only entity that I know that's dedicated to lobbying immigration issues and giving money to Congress people and senators in their campaigns to support immigration issues, because I don't see how any of this, how you change public opinion or how you change the law, unless you're playing the lobbying game. And
that's it.
ALA does it, but ALA's interests are all over the place because ALA members are all over the place. So I think if we're talking comprehensive immigration reform, we got to be talking Ira, Sui Chung, and comprehensive immigration reform.
Yeah.
So
Facebook on that's insane. Another IRA, yeah. So yeah, lobbying is the way to go. Money talks. Even these federal lawsuits and sometimes go back and forth. But okay, so we got the decision on the Title 42. The injunction was lifted. So who knows what's going to happen at the border? It's going to be even nastier. It just is
yeah,
nasty, I guess.
the injunction was stayed there, but it's not my expertise. We'll see what happens in the case in chief. But I've got I've got 2 months worth of cases that I could talk about here, but I can't. Just
Let's
too
pick
much.
the
And
three juiciest ones. So
yeah,
which ones are your favorites?
I picked 3 that are good for the non-citizen and that are focused a bit somewhat on the Ninth Circuit, because that's where you and I are currently located. But starting off, as I often do on the podcast, because when we videotape these things, I've got the week's cases in my mind, even though I haven't had my podcast episode yet. So the first one is going to drop on Monday on my podcast,
which is the immigration review. If you type in immigration, you and my podcast usually the battling for the 1 and 2 spots. So you'll see both of us there.
I appreciate that. Yeah, immigration review. But it drops on Monday. The Fifth Circuit on last Monday issued Rodriguez v. Garland. And, I'm not usually here championing the Fifth Circuit decisions. They're not usually the most non-citizen friendly. But Rodriguez v. Garland, as I read it,
Mm-hmm.
and that could be wrong. I've gotten in trouble before, but
is that the post you did on Instagram where you is this interpretation like
it
that?
It is what I did on Instagram and Twitter. I don't usually go to it, but it seems like the Fifth Circuit said on Monday that an in absentia motion to reopen must be granted based on a deficient notice to appear within the meaning of Ms. Chavez and Pereira that doesn't have the date and time of the first removal hearing. It must be reopened, regardless of whether, it would seem, the non-citizen received the notice of hearing. And maybe that's a bit far, but certainly regardless of whether the non-citizen can overcome the presumption of delivery of the notice of hearing. That's usually the big problem with motions to reopen. There's a presumption that when EOIR sends the notice of hearing, it got to where it's supposed to go. The Fifth Circuit did not care about that in Rodriguez v. Garland. It expressly said, we don't need to address this because the deficient NTA was sufficient, and they remanded it back to the board. And that is because the in absentia motion to reopen statute under the Act.
We're getting comments and stuff I'm posting on the videos. It's distracting a little bit.
I know, I can read them too. And I appreciate it, but and again, for the Facebook users, we can never see the identity of the user, but it seems, and that's because the statute, the motion to reopen statute, expressly references INA Section 239A. It says you need to get notice within the meaning of INA Section 239A. And that's the same statute that lists what needs to be in a notice to appear. And that's the same statute that the Supreme Court was talking about and reviewing in Ms. Chavez. And so the Fifth Circuit is saying Ms. Chavez addressed this. We don't care that it was in the cancellation of removal context. It applies to no notice motions to reopen. That doesn't necessarily, to me, mean that you have to dismiss removal proceedings based on a deficient NTA, because I'm not aware of a statute that initiates proceedings based on a compliant 239A notice to appear. So you're in this weird situation, again, to me, where you don't necessarily dismiss proceedings based on a deficient NTA, but if you don't show up, you have to get it reopened.
Yeah.
I don't know, that does seem crazy. We'll see what happens. And I'm certainly not advocating for not showing up. Yeah. But what a case in Rodriguez v. Garland. And, I think most in absentia motions to reopens happen in the Fifth Circuit, right? I mean, that's Texas, at least. If not the Fifth, then the Ninth. But either way, that's a big deal.
So the poster is actually, the person who asked the question is Una Scott on our Facebook page. Thank you, Una. She asked, what about Arambula-Bravo?
Yeah. I'd have to. I did discuss that last week, Una, as I'm sure you know, the BIA decision. I don't read Arambula-Bravo as mattering for this. Arambula-Bravo said that first of all, I think Arambula-Bravo is mostly about parole and whether or not a deficient NTA terminates parole. And so it doesn't have anything to do with in absentia motions to reopen or necessarily dismissal of proceedings. But they start off their decision, the board, by saying a deficient NTA is not jurisdictional. All right, fine. Honestly, everybody agrees to that. There isn't a circuit I'm aware of that has not held that. That issue is kind of dead. But even in Arambula-Bravo, they footnote and say, we've already said in matter of Rosales that a deficient NTA is a violation of a mandatory claims processing rule. And while the board didn't say it, a violation of a mandatory claims processing rule could lead to dismissal of proceedings. So I don't read matter of Arambula-Bravo as really saying much in regards to whether or not proceedings must be dismissed or not. They didn't reach the claims processing argument because it wasn't made to the IJ below. I can see John's just eyes glazing over right now, but but they didn't reach it because of that reason. And so if it's a mandatory claims processing rule violation, proceedings could get dismissed if you can show that there was prejudice, or based on that Seventh Circuit decision a couple of months ago where I got in trouble, which the name escapes me right now. The Seventh Circuit seemed to indicate that if it's deficient, you dismiss. Now, if timely raised, at least. So definitely raise it going forward. Either way, I don't believe Arambula-Bravo really says anything, and certainly not about motions to reopen in absentia. So, but hey, look, those motions to reopen, Rodriguez v. Garland just blew it up. No matter if you're in the Fifth Circuit or not, you have a strong argument. Yeah. And how many deficient NTAs led to in absentia motions to reopen? It's going to be thousands.
Yeah.
And that can be the difference between adjusting or not, right? Or at least getting consular process with a 601A waiver.
Yeah.
If you can get rid of your in absentia motion to reopen.
That's incredible. I mean, probably thousands and thousands. I mean, that's been the whole procedure for the last many years where they send these deficient notices. The standard operating procedure, hasn't it? Where it's constantly coming out. Well, thanks. So what's the next case on that?
So it's been 2 months, John, and I had to get a bit heady, but I hope I always try to say these in a way that, I mean, I know that you're not a removal defense attorney, so I'm always trying to make it such that,
Thank you.
and not that, but like that anyone, even a non-immigration attorney, I say it on the show, my 90-year-old grandma listens to my podcast. And actually, I talked to her about aggravated felonies. So if my grandma can understand it now, that's the goal, right? Alfred v. Garland, though, out of the 9th on September 22nd, I don't know if there's a way to. It's just crazy, and it concerns a 2017 decision out of the 9th Circuit called United States v. Valdivia Flores, and it's essentially reaffirming Valdivia Flores. And this Alfred v. Garland panel, the 3-judge panel. All 3 of them didn't want to issue this decision. It's very funny. They all concur with the decision. I love when they do that. Like, they write it and then they're like, we don't want to do it. But they feel like they had to do it under precedent, even though that there was other precedent predating Valdivia Flores that might have undercut it. And the issue is this. It's about the categorical approach, whether or not a conviction is an aggravated felony. But honestly, I think that this case applies even beyond aggravated felonies. And that is, in Washington state, apparently, as with most states, really, accessory, aiding and abetting a crime is charged the same as if you're the principal. So if you're an aider and abetter to robbery, they charge you the same as if you did the robbery.
Yeah.
But apparently in Washington state, and I don't know how many other states are like this, the aiding and abetting it's indivisible from the principal. So like you could get convicted of robbery and a jury wouldn't have to determine whether or not you actually did the robbery as a principal or whether you merely assisted in doing it, aiding and abetting. All right. So it's indivisible. The jury doesn't have to find if you're the principal or the aider and abetter. And the 9th Circuit in Valdivia Flores says, okay, it's indivisible. And the Washington state aiding and abetting statute covers more conduct. It's easier to get aiding and abetting conviction than does the federal aiding and abetting statute. That makes the aiding and abetting statute broader than the federal corollary, which means that the aiding and abetting statute doesn't match the removable offense. And because it's indivisible from the Washington crime, any Washington crime, every Washington crime doesn't match a removable offense. Or at least a removable aggravated felony, because it always includes aiding and abetting, right? And aiding and abetting is always broader than the federal removable aiding and abetting offense. And so it's like, that's 2017. I'm like, people who were watching, like myself included, are like, wait a minute, does that mean every crime in Washington is not a removable offense? or at least not an aggravated felony. And in Alfred v. Garland, 3 years later, last week, the Ninth pretty much said, yeah, at least, at least, at least with aggravated felonies. And this time, it wasn't just aggravated felonies that are defined by a statute, as was the case in Valdivia Flores, but to aggravated felonies also that are defined by the common law, which was at issue in Alfred. Either way, I don't know. If I'm not right, there's certainly the argument that Alfred v. Garland and Valdivia Flores mean that a Washington conviction cannot be a removable offense, at least in the Ninth Circuit, which is, of course, usually where a Washington state conviction is going to arise for immigration purposes. And it certainly means this for aggravated felonies. So, I feel like I feel like United States v. Valdivia Flores was kind of sneaking under the radar all these years because it wasn't a petition for review case. It's the federal defenders that keep making this argument, but Alfred v. Garland is, I don't know, y'all. If you have a Washington state conviction, off to the races with Valdivia Flores and Alfred v. Garland, because I don't know. I think you got to terminate. It's nuts. It's great.
So we're 2 for 2 on groundbreaking cases, and that it reopens thousands of cases and everything. I mean, if you're a removal attorney, you have to go back on all your cases and start looking, and it's just insane. It's insane is the best way to put it. I think it's wild.
It's a good insane, and actually the third one I chose is also groundbreaking.
There we go. What's the next one?
Yeah, this is Diaz-Rodriguez v. Garland out of the Ninth on September 10th, and this is about crimes of child abuse, child neglect, and child abandonment, which is another 237 removability provision, and the presidential board decision on that is matter of Saram, and a decision right before matter of Saram as well. And whether matter of Saram should get deference, all the circuits have deferred to matter of Saram, which essentially said that a state conviction, in this case California child endangerment, will be a crime of child abuse, neglect, or abandonment if it allows for a reckless, a criminally negligent mental state, and a sufficient degree of risk of harm to the child. So if you mess up really bad, even if your kid doesn't get hurt, if there's a pretty high risk of him getting hurt or her getting hurt, you have the state conviction can match the federal removal offense. And the Ninth Circuit actually deferred to matter of Saram, but then the Ninth Circuit went and bonk on the case. This is Martinez-Cedillo v. Sessions, and I got all this from the decision itself. The Ninth Circuit defers to matter of Saram in Martinez-Cedillo v. Sessions about California reckless endangerment. They defer to matter of Saram, find that California reckless endangerment is a crime of child abuse, neglect, or abandonment. But then the court goes and bonk on it, and while they're in bonk, Mr. Martinez-Cedillo passes away. And so the case is moot, and the Ninth Circuit vacates all of Martinez-Cedillo. In the interim, 2 panels relied on Martinez-Cedillo in a published decision, but this panel is saying that was error because now there is no Martinez-Cedillo. So now this panel gets the very same issue and says, we don't agree with Martinez-Cedillo. We can do that because there is no Martinez-Cedillo. We are not going to defer to matter of Saram. We don't agree that child abuse, abandonment, or neglect covers one separate definition, but instead covers 3 separate definitions. And we hold that a crime that has a criminally negligent mens rea and doesn't require harm to the child isn't going to cut it. Wow. And that's paraphrasing a very complicated decision, but this always comes, look, there are some child abuse, first of all, not condoning child abuse. There are some child abuse crimes that you're always going to happen, like sexually touching, all that horrible stuff. But this area is really talking all about the reckless endangerment crimes that happen that every state has, in which if you leave your
kid in the car,
that's bad too. Don't get me wrong. Should it make you removable if you mess up? That's more of a policy question. But from a statutory interpretation question, the Ninth Circuit is saying a crime like that, it would seem, isn't sufficiently bad to make you removable. And one of the ways that it is interesting, and I love the argument, it's a second argument that the Ninth Circuit makes, is that, okay, they say, look, non-LPR cancellation of removal is there So if a kid, a U.S. citizen kid, is going to suffer exceptional, extremely unusual hardship if their parent is deported, the parent should stay. That's what non-LPR cancellation of removal essentially is, right? At the same time, if the parent is convicted of a crime of child abuse, abandonment, or neglect, they can't get cancellation of removal. So the Ninth Circuit said, theoretically, you could have a parent whose removal will cause exceptional and extremely unusual hardship to their U.S. citizen child, who nevertheless cannot stay because they were convicted of a crime that did not physically injure the child and that allowed only for a criminally negligent mental state. That doesn't make sense to us. And so I just love that rationale wherein you use the fact that there is cancellation of removal and all of these crimes bar it to say, okay, but the definition of those crimes then must be sufficiently severe because what's at stake is removing a parent whose removal will cause exceptional, extremely unusual hardship to their child or their spouse or whatever.
Mm-hmm.
I love the logic. It's kind of using a sword under the INA, which is all these disqualifying crimes for cancellation. It's kind of using that sword as a shield to then make something that is non-citizen friendly in statutory interpretation. So all three of those cases blew my mind.
Yeah. We missed out on a lot of stuff, so it's just wild how these decisions come out. I agree with you. And that's one of the reasons I don't dive into this kind of stuff, because you got to be reading this stuff all day. No time to have a magazine or do the podcast. Well, you make a podcast happen, but you kind of
make my podcast, you make your magazine. We both do our work when we can, but I love this stuff. I know you do too. I mean, this is the fun stuff to me, and you don't always get cases that involve these complicated issues. I'm fortunate enough that I get a lot that do, but like reading the cases, analyzing them, it kind of, it makes every week a complicated, intellectually stimulating week for me. I like it.
Immigration is always new and it's always intellectually stimulating. So if that stuff is enticing, this is the best field there is. It's amazing. Well, thank you so much for coming on again. We'll be back next month, and congratulations on the wedding, the anniversary, and the success of the podcast, Immigration Review. It's really kind of you to come and give us a synopsis of this stuff. I really appreciate it, Kevin.
Thank you, John. Congratulations on remaining married, having the kids, and the success of your podcast and your new magazine. I think that's an even better accomplishment.
Thank you so much. Well, I guess until next one, God bless, be safe, and we'll talk with the fans later and the listeners. Bye-bye.
Hi, John. Thank you.